Welcome to Week 11's recorded lecture. We continue our discussions of hearsay with the cases from your casebook on pages 405 to 453. The first case that we covered was Williams v. Alexander. This is a Court of Appeals case from New York from 1955. In this case, Williams was hit by Alexander's car. The two parties then gave very different descriptions of how the accident occurred. The plaintiff wanted to introduce part of his hospital record that was relevant to his injury and his treatment. The defendant then wanted to introduce, after the plaintiff objected, the rest of plaintiff's hospital record. The record had an entry by the plaintiff's physician, quoting plaintiff saying that car A, which was Alexander's, was at a standstill, and then was struck from behind by car B, which then pushed Alexander's car into the plaintiff's car. This then substantiated the defendant's story of how the accident occurred. The issue was whether the defendant should have been allowed to introduce the plaintiff's complete hospital records over his objection. The Court of Appeals here ruled that the admission of the entry had been an error. The majority held that the detailed description of the accident entered by the plaintiff's physician was not within the ordinary course of the hospital's business, which is what's needed to qualify for a business record exception. The majority felt that it would have been within the ordinary course of the hospital's business to note that the plaintiff was struck by a car, but not to note whether car A had struck plaintiff under its own power or was hit by another car and pushed into the plaintiff. Their thinking was the rationale for the business record exception is that if wrong information is contained within the record, the business would then be acting on that bad information. However, in a dissent, the dissenting judge felt that it should have been and was the duty of the ER physician to ask how his patient was injured, and that the detail that was put into the plaintiff's hospital record is actually needed to properly treat a patient. And do you agree with that? I do think that it's not a stretch to say that a doctor inquiring into the details of an accident could be relevant to their treatment for you. The next case we covered was Palmer v. Hoffman. This is a Supreme Court case from 1943. As background, we have a plaintiff who brought an action to recover for injuries to himself and for the wrongful death of his wife. The accident resulted from a collision with the defendant's train. At trial, the defendant wanted to introduce statements by the train engineer to railroad officials inquiring into the accident. These inquiries were conducted and recorded every time there was an accident with the railroad. The engineer then died before trial. The plaintiff objected to admitting the record with the railroad engineer's statements. At issue was whether these statements were properly introduced as part of the railroad's business record. The Supreme Court held that the statements did not fall within the business record exception, and that because of that, they were inadmissible. The court felt that the railroad's normal business records should have been just about the railroad, and these specific records that were documenting any of the accidents were not actually within the ordinary course of business, and instead were only made for the purpose of litigation, which then made it lack trustworthiness. The next case was similar. This is Lewis v. Baker, a United States Court of Appeals for the Second Circuit from 1975. The background facts here were similar to the last case in Palmer. This case was also about a railroad accident. However, the employees of the defendant in this case had made statements 4 hours after the railroad accident. And also the difference here was the employees were not involved in the accident, unlike in Palmer where the statements were made by the engineer who was conducting an investigation of the accident. After Palmer, should these statements by the railroad employees be admitted, even though they were discussing the accident, similar in the last case in Palmer. Here, however, the court held that yes, the accident reports could be admissible when there are circumstantial guarantees of reliability. So in this case, the statements were made by employees who were not involved in the accident, and therefore they were not worried about being sued. And so because of that, that made their statements more trustworthy. Our next case is Sana v. Hawaiian Cruises. This is the United States Court of Appeals for the Ninth Circuit from 1999. Sana worked on a cruise ship, and he fell ill with an infection and then fell into a coma. He brought an action against his employer seeking maintenance and cure, which under maritime law, if he fell injured while in service of his vessel, he would have a strong case to recover compensation. The plaintiff wanted to introduce a report by Rutherford, who was an insurance agent for the employer, which was describing interviews with Sana's coworkers. Two of the coworkers stated that Sana told him he was injured while he was working. At issue was the admission of the insurance agent's report, which had 3 different levels of hearsay. The first being Sana's statements, the second being the coworker statements, and the third being Rutherford's statements, which was the report itself. The court held that Sana's statements were admissible under FRE 8033, which is the exception for describing then existing bodily or mental condition. They then held that the coworker statements were admissible as an agency admission because the workers were acting under their employer and had a responsibility to participate in these investigations of Sana's injuries, and they wouldn't have given those statements if it was not their job to do so. The court then held that Rutherford's statements was admissible under FRE 8036, the business record exception. The next case was Beech Aircraft v. Rainey. This is another Supreme Court case from 1988. As background, in this case, this was a wrongful death action against an aircraft manufacturer. The suit was brought by the survivors of 2 naval aviators who were killed in a training exercise. An investigator made a report describing the facts and offering his opinion that the likely cause of the crash was pilot error. The plaintiffs argued that this was an opinion and not a factual finding within the scope of FRE 8038C, which permitted the admission of reports that were containing factual findings if they were derived from investigations made under the authority of law. At issue is whether the investigators' reports did fall under this exception. And here the Supreme Court held that yes, the opinion was admissible. They interpreted this code section to admit opinions within investigative reports as long as the report also contained factual findings. Next case was Williams v. Illinois. This was another Supreme Court case from 2012. As background with this case, a woman had been raped. Afterwards, a doctor took a vaginal swab from the victim and employees of the state police. They then sent that swab to an out-of-state lab for DNA analysis. The lab sent back a report, which was signed by 2 reviewers, asserting that the swab contained male DNA, a different kind of male, and gave a profile for Sandy Williams. Williams had not previously been identified as a suspect, but he was a plausible suspect. So he was from Chicago, where the crime had occurred, and the victim identified him, though she wasn't certain when she made that identification. At the defendant's trial, the report was not introduced, but instead a forensic scientist for the state police testified that the computer program had matched the profile generated by the out-of-state lab with the defendant, and that, in her opinion, there was a match. Without that scientist's testimony, the defendant would not have been convicted. At issue is whether there was a confrontation clause violation at trial. The court held that no. There was 2 grounds for no confrontation clause violation. The first grounds being the report was not admitted to prove the truth of the matter asserted. In this case, the scientist was testifying that there was just a match between 2 DNA profiles, not that the lab's profile was in fact derived from a vaginal swab of the victim. However, it's important to note here that this was not the majority opinion. While there was a split majority in this case, the majority opinion written by this judge was not signed on by many of the other judges. The second reasoning here was that the report was not testimonial, meaning not formal enough to be for litigation, and not for the primary purpose of accusing a targeted individual. Again, note that 4 other judges rejected this argument. So what does this holding mean for the future of admissibility of reports like this? In these circumstances, a DNA test report made without a previously identified subject would then not be testimonial for the purposes of the confrontation clause. Our next case is United States v. Towns. This is the United States Court of Appeals for the Fifth Circuit case from 2013. In this case, the defendant was convicted of drug-related crimes. At trial, purchase logs from pharmacies were introduced against the defendant. The defendant argued that these records were improper business records because they were only kept because the state mandated that they be kept, and therefore should not have been introduced. The defendant argued that the underlying rationale for the business record exception is that because they're kept in the regular course of business, there was an element of trustworthiness to them because a business would not rely on improper records to run their business. But that in this case, because the state was mandating these records, they had an element of untrustworthiness. So at issue was whether these pharmacy purchase logs did or did not qualify as a business record exception. In this case, the court rejected the defendant's arguments. They held that the exception doesn't actually ask whether the records the exception only asks if the records are kept in the regular course of business, not that the business rely on their truthfulness. The court also held that the logs were not testimonial. That was our last case for this week. We will end with the casebook hypos 1 through 9 on pages 252 and 253. We will then have one more week of discussing hearsay before we move into our review for the end of the semester.